In the name of Almighty Allah, the most merciful. My dear audience, in our today's session, we will discuss a very important doctrine relating to the corporate sector. And this dictum, or this, in fact, aspect pertaining to the corporate sector is known as veil of incorporation. And as we know that this veil or this shield is available to any company which is duly incorporated by the regulator. When we discuss a company incorporated in Pakistan, and we talk about the regulator, that is Securities and Exchange Commission of Pakistan. So under Companies Act 2017, when a company is incorporated, we can say that that company assumes the status of an artificial legal person. And being an artificial legal person, that company is known as a separate legal entity. And resultantly, the directors of the company, they have limited liability because company owns the responsibility once it is incorporated. And on account of this incorporation, on account of this registration of the company, we can say that, as I said earlier, that there is a curtain available between the company and the directors. And that is especially with regards to the liability of the company. And in case if there is any claim by the company or from the company, that claim can be adjusted from the assets of the company, and directors' personal assets are not to that claim. That very concept is known as veil of incorporation. In this session, we will discuss that the veil of incorporation, whether that can be lifted, and what are the circumstances which can result into the lifting of the veil of incorporation. In this session, we will discuss the judicial decisions, decisions rendered by the Honorable Superior Courts, and on account of those decisions, this veil of incorporation can be lifted. Now, in this discussion, we will have a very recent judicial precedent. It is rendered by the Honorable Supreme Court of Pakistan, and that relates to Malir Development Authority, Town Private Limited. These were the important parties. We will discuss at the end that judicial decision, what are the different, key aspects of that decision. So let's start with this topic of judicial decision. And may I ask Mr. Mehdi Raza to do the reading for the participants. Mr. Mehdi Raza, please.
Thank you, sir. Okay, so judicial decisions. The corporate veil can be lifted under the following judicial decisions. A, protection of revenue. When a company is formed for the purpose of tax evasion, the court may be disregard the corporate entity.
Right.
Sir,
you see, we will talk this case law in a minute. You see, for the sake of revenue, as we know that to protect the revenue or to protect the earnings of the exchequer, this is the responsibility of the regulator. This is the responsibility of the courts of law, that if someone has made a company that is a sham company, that company does not exist or does not do any business, and that is solely meant for avoiding the tax, or that is meant for evasion of the tax, then of course, if this is proved, then the court can lift the veil of incorporation, and there can be recovery proceedings against the directors as well as the company. Yes, Mr. Mehdi Raza, please.
Sir, Dinshaw Manekji Petty, Air 1927, Bombay 371. Dinshaw created 4 private companies for the purpose of tax evasion. He transferred his income to the 4 companies. He got loans from the 4 companies and never repaid. The court lifted the corporate veil of all four companies and held that they were created to conceal Dinshaw's income.
Is right. You see, as we know, that if an income of one company is 1 million rupees per annum, and if you divide that, and that 1 million falls within of income tax liability. So, in order to that income tax liability, at times people form companies which are not active companies, which are not meant for conducting any business. The sole company is to divide the income into four. As I said, that a company, if it an annual income of 1 million rupees, that falls within the slab, within the ambit of tax payment. And if you divide that into four companies, resultantly, none of the company, if slab is 4 million, 4 lakhs rupees, and as I said, that the income of a company is 1 million. So any earnings or profits above 4 lakhs rupees is subject to the payment of tax. But if you, instead of showing one company earning 1 million rupees, if you just mention that there are four companies is earning 250,000 rupees per annum, and you know that that will be less than the tax liability slab, and resultantly you will not be liable to pay any tax. So for this purpose, sometimes people make companies, and this really had happened in the precedent we have cited, and the court has lifted the veil of incorporation, and the court has conducted or directed for the conduct of investigation against the company and ancillary companies or associated companies. The second point, Ms. Please read the second point, company as agent, please.
Okay. Company as agent. When a company acts as an agent or trustee of the shareholder, it loses its corporate entity. In such circumstances, the court may lift the corporate veil.
Please go through the precedent.
Merchandise Transport Limited versus British Transport Commission. A transport company wanted to obtain licenses for its vehicles, but was not allowed to apply in its own name. It formed a subsidiary company and applied for licenses in the name of subsidiary, held the parent and subsidiary company were one unit, and the application was rejected.
Absolutely right. So you see, because it really happens in Pakistan that sometimes for the public services, let's say that Pakistan provincial government intends to go for another like Orange Line train service, intends to go for you see Green Line service, another transit railway facility, and just advertised for the bids to those companies who are interested to construct Green Line transit rail service. And let's say that there is a company which is blacklisted, and so that company cannot apply for that, cannot procure that assignment. So instead of applying with its own name, makes a subsidiary company and move an application on behalf of that subsidiary company. So that you see that arrangement is not permitted in law, and that is what really happened in this case. Now, contractual obligation is the next point. We are discussing here the judicial decisions that on these bases, judicial decisions can be rendered to lift the veil of incorporation. And let's have some other member, a female member of the participants. Please read this contractual obligation. Any volunteer, please?
Sir, can you hear me now?
Yes, Ms. Umal Zahid, please do share obligation with the participants.
Um, Contractual obligation. When companies incorporated to avoid legal obligations, the court may lift the corporate veil.
Right. So when the company is incorporated to avoid legal obligations, then of course the veil of incorporation can be lifted. There is a citation on this point. Please share the citation with the participants.
One was a former employee who had an agreement with G. Corporation not to persuade
Yes,
its customers. Horn formed a private company and started competing against G Corporation, filed a suit against Horn and the private company. The court restrained Horn and his company from competing.
absolutely right. You see, in this case, what happened? That Horn was an employee of the company, and he has this contract with his parent company where as an employee that he will not form his own company, imparting the very service his parent company was providing. And that was a contract, that was a contractual obligation he has undertaken. But subsequently, in violation of that contract, he started offering the similar services and to the clients, which were initially the clients of his parent company. Resultantly, in order to ensure that Horn should not infringe or violate the contract he has made with his parent company, court has restrained him, stopped, refrained Mr. Horn not to compete with his parent company. So this is regarding the fulfillment of contractual responsibility. Ms. Umal, please read the next point. That is fraudulent purpose.
Fraudulent purpose. The corporate veil may be lifted by the court where a company is formed for fraudulent purpose. Genker ACP Limited versus Dalby 2000.
Yes.
Dalby was a director of Genker ACP Limited. He fraudulently shifted assets to another company owned by him. Dalby and his company were ordered to return the money as he did this act without the consent of shareholders of Genker AC Limited. The court lifted the corporate veil between Dalby and his company.
Right. You see, I mean, any decision uh, pertaining to the assets of the company cannot be made without due consultation with the shareholders and stakeholders. This is really important, and you people will study the corporate governance regulations, and you will find that there are certain areas earmarked or certain areas categorically given in Companies Act's relevant sections and in corporate governance regulations, where it is explicitly and expressly provided that these areas or these decisions board of directors cannot make at its own. It is the prerogative, or it is the domain, or it is the discretion of the stakeholders, the shareholders. So for that purpose, annual general meetings to be held in order to make the decisions which cover the areas which are within the purview of areas which cannot be decided by the board of directors only. And the same has happened in this. Now, character of company is the next point. Ms. Khushbakht, can you please share this point with the classmates?
Yes, sir. Controlling its affairs as citizens of an enemy country. The court may lift the corporate evil to examine the character of company.
Right. This is interesting. The character of company, actually, this is in terms of the fact that whether that company is not involved in money laundering, or is not involved in any act which can prejudice the interests, the legitimate interests of that country. Let's say that case we will find that there is a company which is not serving the best interest of the company, and that to an enemy country. So here the court has passed a judgment. Let's read that judgment. Yes, Ms. Khushbakht, please.
CTR covers marketing German
Miss,
tires in
please pause here
England.
for a minute, Miss Khushbakht. Perhaps your 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 reception not up to the mark. Miss Khushbakht, please pause here. Your reception has a problem. Let me ask Miss Mehrun Nisa to read this citation for the audience. Daimler Company Limited versus Continental Tire and Rubber Company, 1916 to AC 307. Miss Mehrun Nisa, can you please share this citation with the participants? Ms. Khushbakht, your voice quality is not up to the mark. Especially, I think there is some reception issue. Have Miss Mehrun Nisa to do this reading. Mr. Mehdi Raza, please do this reading. Daimler
Sure, sir.
Limited. Yes, please.
Daimler Company Limited versus Continental Tire and Rubber Company 1916, 2AC 307. CTR Company was marketing German-built tires in England. The majority of CTR shares were held by German nationals. During the World War I, CTR Corporation filed a suit against an English Daimler Corporation for recovery of trade debts. Daimler Corporation refused as CTR Corporation was owned by German nationals and Germany was at war with England. The court lifted the corporate veil and found that CTR Corporation was in fact owned by German nationals.
That's right. You see, here is the character of the company, and it is found that company relates to Germany. The German nationals, they were holding the majority share of that company. And since we know that during the World War, Germany and England, they were at daggers drawn. So when the matter came to the court of law, court has discussed the character of the company, and it was found that the company is owned by German nationals, and Germany was declared on account of World War as enemy country. So the company actually was also considered as an enemy country, as an enemy company on account of the fact that that was owned by the nationals of an enemy country. And in this case, it was Germany vis-a-vis England. Okay, so these are the certain aspects we have discussed pertaining to the question that how the veil of incorporation can be lifted. Let's conclude our today's topic here. Thank you very much for your participation. In the name of Almighty Allah. In the first session, we have discussed different aspects regarding lifting the veil of incorporation. And initially, we discussed the statutory provisions which are provided in Companies Act 2017. And regarding those statutory provisions, if there is any violation of the same, the veil of incorporation can be lifted. On the other hand, we have discussed the court decisions where the Honorable Court of Law can direct that in the given circumstances, veil of incorporation should be lifted and there should be formal investigation against the company. In the most of the citations regarding the court decisions were from English jurisdiction. Now I'd like to share with you the citations from Pakistani jurisdiction. One of the landmark judgment rendered by Honorable Supreme Court of Pakistan, that is Pakistan Law Decisions, 2018 Supreme Court, page 468. The title of this citation is Sayyid Mahmood Akhtar Naqvi versus Malik Israr, Senior Member Board of Revenue, Sindh. The background of this citation is that basically this Senior Member Board of Revenue, Sindh, he was involved in swap of land, which was owned by Malir Development Authority. And that exchange of land, swap of land, was done with Bahria Town Private Limited. So when the matter was taken up by Honorable Supreme Court, especially the of separate legal entity, this concept of limited liability, these were discussed in this judgment. So we will have the reading of this judgment, especially the important aspects, in order to understand that whether if there is a statutory violation, that veil of incorporation can be lifted as it was lifted in case of Bahria Town Private Limited. And we know that Honorable Supreme Court of Pakistan has imposed a penalty worth billions of rupees on Bahria Town Private Limited, and in order to safeguard the legitimate interests of the province of Sindh, in order to safeguard the land of Sindh situated in Malir Development Authority. And in this judgment, this is really a very landmark judgment, an authoritative judgment, because through this judgment, the Honorable Court has safeguarded the legitimate and lawful interests of hundreds and thousands of families. So let's have a quick look. I'd like Mr. Mehdi Raza to start the reading. Mr. Mehdi, please.
Delhi 2018 Supreme Court 468 Sayyid Mahmood Akhtar Naqvi versus Malik Asrar, Senior Member Board of Revenue. So sections 10, 2A, 10.4 and 17 Mali Development Authority Act 1993, 11 of 1994, sections 4A, 8, 9 and 14, adjustment of government land with land belonging to a private real estate developer, illegalities. Allegation that the value of the government land was far higher than the value of the private land it was exchanged for. Validity, per Ijaz Afzal Khan, is the majority view. Enormous tracts of government land were granted by the Provincial Board of Revenue to the Development Authority for launching incremental housing scheme. Development Authority, instead of launching the scheme on the land thus granted, exchanged it with private real estate developer through its henchmen. Power to declare an area to be a controlled area laid with the Development Authority. Notification issued for declaring subject government land as controlled area was issued by Senior Member Board of Revenue, who did not figure anywhere in the entire scheme of the Mali Development Authority Act 1993 in general, and Section 14 in particular. Corrigendum at the later stage has been issued showing that the notification was indeed issued by the Provincial Secretary, Local Government and Housing, Town Planning Department, but he too being a non-entity in the Mali Development Authority Act 1993, neither had the power to declare an area to be a controlled area nor issue a corrigendum. Development Authority, without preparing the master plan and scheme that the private real estate developer initiate, embarked upon private housing scheme. No evidence was presented to establish that managers of the real estate developer requested the Development Authority for assistance in the preparation of the scheme, and what terms and conditions have been settled in between them as required by Section 17 of the Mali Development Authority Act 1993.
Absolutely right. You see, the points we have just read, if we discuss them one by one, first of all, we get to know that the land owned by Mali Development Authority required, or which was acquired for the sake of establishing a housing society, that land was given to a private developer, Bahria Town Private Limited. And the important aspect is that the order was passed by an authority who was not competent to pass the said order. And resultantly, it was found that keeping in view Mali Development Authority Act 1993, it is not provided in the law that this way land can be swapped or given to a private entity, which is primarily meant for the public, which is primarily meant for the common man. And so this was one of the point which was taken into consideration. And in general public interest, in vital public interest, Honorable Supreme Court of Pakistan has taken the cognizance of this matter. And moreover, this is important that in law, if an authority is defined, that authority is competent to pass such an order. And if it is not done in that same manner, that is again amenable to the constitutional jurisdiction or to the jurisdiction which can be exercised by the apex courts of Pakistan. Let's have a further discussion on the topic. Let me invite Ms. Mehrun Nisa to do the next reading.
Question was as to how the development authority owned or housed a housing scheme of the real estate developer, which was prepared by the latter on its own without the assistance of the former in terms of Section 17. Two, and how could the housing scheme be held to have been prepared, undertaken, or executed under the Malid Development Authority Act 1993 in terms of Section 2 of the said Act, Section 10 2A of the Colonization of Government Lands Act 1912, provided in
Equivocal
unequivocal
terms, yes.
terms that a land granted to any person under Section 10
It's not exchangeable with the private land, actually. So the law does not provide that Malid Development Authority's land can be given to a private entity or to a private housing society. Let me request Ms. Ifra to do the next reading. Ms. Ifra, please. I'm afraid I can't hear Ms. Ifra. Let me request Mr. Mutahir.
Okay, sir. Should I start?
Please.
Question was as to how the development authority owned or espoused a housing scheme of the real estate developer, which was prepared by the latter on its own without the assistance of the former in terms of Section 17, Clause 2, and how could the housing scheme be held to have been prepared, undertaken or executed under the Malay Development Authority Act 1993 in terms of Section 2 of the said Act, Section 10 2A of the colonization. Sorry, sir, the line is above.
Here we go.
Could you please move it backwards? It's
Let me take this point from here, and let me explain initially that the law, which was the enabling law, which can provide the powers to the Military Development Authority to exchange land, those powers not available with those officials, and those officials have acted with patent illegality, and on account of this illegality, the Honorable Supreme Court of Pakistan has found that there are statutory violations. And if you remember, in our discussion, we have discussed that if law has categorically stated that an act is required to be done in a certain manner, and if it isn't done in that manner, then of course the whole proceedings will be void ab initio. And this happened in this case, that the Honorable Supreme Court has said that neither the authority which has allowed the swap of land nor the law has provided to the authority exercise that jurisdiction which was exercised. One more point, let me take from here. Mr. Danish Fahim, I'd like you to read these few lines, enabling me to explain this point as well to our class.
Subject exchanges consolidation of lands was the basis of development of a housing scheme that had not only brought huge revenue and created opportunity for such generation with a much greater proportion in future also, but had given to the city a new housing scheme with massive infrastructure, utilities. Land was mainly owned by provincial government and had given boost to the development activities around it, and it was likely to contribute to the economic activities and well-being of the people who had been living in and around the area since before it's developed.
That's right. You see, this was an argument which was in favor of Bahria Town Private Limited, that Bahria Town Karachi has developed that area, and that is really meant for the general public also, or especially in the vicinity. The area has also been benefited by the road network and by the other amenities which are provided by the Bahia Town Private Limited. So that was some sort of contributing effect or that has resulted into a kind of beneficial judgment that Honorable Supreme Court in public interest has decided.
Sir, we can.
Okay, so now let me ask Ms. Aroma now to conclude the last paragraph, please.
Subject exchanges had been done lawfully and did not suffer from any blemish, and there was not even a prima facie evidence of any mera fide in such regard, nor had it been alleged that any officer involved in the exercise made any personal gain out of it. His Lordship directed that since some of the lands received by Development Authority in exchange from the private owners were distantly located, and the real estate developer had himself offered re-evaluation of the lands involved and to pay any further amount found due and payable, therefore a committee shall be constituted to assess and evaluate the market prices of the land exchanged between Development Authority and the private owners or real estate developer that prevailed at the time of the exchanges.
Absolutely right. So, furthermore, it's not only that the Bahia Town Private Limited has developed a new city in the outer skirts of Karachi, but also this very aspect is taken into consideration by the Honorable Supreme Court that if there is any anomaly or if there is any shortcoming in the payment or the market price is not being paid to the Malay Development Authority, Honorable Supreme Court has ensured that the market value should be ensured to be paid by Bahia Town Private Limited to Malay Development Authority. And as you know, that any income, as it is perhaps in your knowledge, that very often in housing societies in Lahore even, the government plots or government amenity plots with the permission of authorities are sold out to the private entities or private companies just to raise funds and to use those funds for the public good, for education, for health facility, or for the development of infrastructure. So then the Honorable Court has taken this view that there are certain beneficial aspects of Bahia Town Private Limited Karachi, and on account of this, the Honorable Supreme Court did not set aside the whole undertaking. And second very important aspect was that public at large has invested their billions of rupees. And this is why the moderate approach is adopted and just to serve the beneficial of the public at large. So this was the judgment, which is the recent landmark judgment on the subject matter. And as you know that though Bahia Town Private Limited is a limited company, there was a veil of incorporation between the company and the board of directors and its chief executive officer. But if you find the proceedings of the court, and especially if you find on the, if you read the newspapers when in the year 2018, this case was undertaken, and you read the proceedings of the court, the chief executive officer and chairman board of directors, he was directed by the Honorable Court to appear in person, and that veil of incorporation was lifted, and his personal assets were made amenable for any recovery proceedings. And this is one of the glaring example that in spite of the fact that there is a veil between the board of directors and the company, or the directors have the limited liability, but still.
Sir, I have a question.
Please.
I couldn't really get to the verdict of the Solomon case. I think we haven't even read about it yet, but that was a smart move, having the debentures of the company. But considering as investors, wouldn't the investors already notice something like that, that the owner is actually getting the debentures instead of the shares? There is something fishy in the business going on, because
That's
that
right.
would be a clear sign.
Yeah, Mr. Mutai, this is the whole, in fact, gist of the decision, and it will be shared with you on the CMS. So you'll be able to go through it in your own time, and you will find ultimately that the court of law finally found that mischief in the strategy of Solomon. And if I just quickly go through the final decision by the House of Lords, it was the company is at law a different person altogether from the shareholders. And though it may be that after incorporation, the business is precisely the same as it was before, and the same persons are managers, and the same hands receive the profits, the company is not in law the agent of the shareholders or trustee of them, nor are the shareholders as members liable in any shape or form except to the extent and in the manner provided by the Act. That was the final decision by the House of Lords. You will go through it and you will find that actually there is a veil between the members and the company. And that veil of incorporation, it can be lifted in some circumstances, but in Solomon versus Solomon, I leave it up to your reading actually, that let's come up with this answer in a later session, that whether the veil was lifted and Solomon was personally held liable to pay off to the unsecured creditors. So with these words, I thank you for your participation. All the best. Allah Hafiz.